We have a major new development in one of the most critical Second Amendment cases in the country right now, and the federal government has been caught red-handed. The Department of Justice just filed another brief defending the National Firearms Act, and the plaintiffs have fired back with a devastating new motion. The accusation that the Trump DOJ is blatantly breaking court rules, trying to sneak in last-minute evidence to save a case that is rapidly crumbling beneath their feet. This is one of the most desperate legal maneuvers I have seen in a Second Amendment case. Right now, as we speak, the DOJ is under fire from plaintiffs in a massive nationwide challenge to the NFA. They know they're in trouble. They know the ground has shifted, and they are trying to play fast and loose with the law to keep their grip on your constitutional rights. So today we are breaking down the absolute chaos developing in the Northern District of Texas, what the Trump DOJ led by Pam Bondi is actually doing behind the scenes, and why this procedural sneak attack might actually be the smoking gun that proves the NFA is finally dead in the water. The question at the heart of this entire battle is simple, yet it's the one thing the ATF and the DOJ are terrified to answer honestly. If the tax is gone, how can the regulation remain? For nearly a century, the federal government has used its taxing power as a Trojan horse to register, track, and restrict your suppressors, your short-barreled rifles, and your short-barreled shotguns. But as of January 1st, 2026, the world changed. The taxing power they've leaned on for decades has been hollowed out, and now that they've been caught trying to fix their weak arguments with shady procedural moves, the plaintiffs are going for the jugular. Now, if you've been following along for a while, you know that H.R. 1 passed. You might remember it being called the One Big Beautiful Bill. When this passed, it didn't just shuffle some paperwork in D.C., it fundamentally rewired the relationship between the American gun owner and the federal government. Through H.R. 1, we saw the most significant rollback of NFA-related costs in history. The tax on suppressors, short-barreled rifles, short-barreled shotguns, and any other weapons was slashed. It didn't just go down a little bit. It didn't go from $200 to $100. It went from $200 to $0. As of January 1st, 2026, that $200 tax stamp that has acted as a financial barrier to entry for law-abiding citizens for almost 100 years was effectively eliminated. Now, the government still wants you to register the items. They still want the paperwork. They still want the months-long wait times. But the tax, the very thing that gives them the constitutional hook to regulate these items in the first place, is now non-existent. After that happened, there were several Second Amendment groups and plaintiffs who decided to move forward and try to finish the job and get rid of the remaining restrictions, like the transfer restrictions, the registration process, and all of that, trying to leverage the $0 tax to dismantle the remaining NFA requirements. In this case, the silencer shop challenge against the ATF, you had Gun Owners of America, the Firearms Regulatory Accountability Coalition, or FRAC, Silencer Shop, Palmetto State Armory, and Silencer Co., who joined together to file a lawsuit against the ATF. On top of this, you also had multiple states that joined into this lawsuit as plaintiffs. The core argument of this case is very simple and very powerful. Because these firearms are no longer taxed, Congress, they argue, can no longer justify regulating these items under their taxing powers. Therefore, they argue the NFA's registration and transfer requirements exceed Congress's enumerated powers. This created what we call a legal gap, and it's a gap you could drive a truck through. For those who aren't familiar with the constitutional weeds, here is the deal. The federal government does not have a general police power to regulate whatever they want. They have enumerated powers. When the NFA was passed in 1934, the Supreme Court eventually said, look, the federal government can't just ban these things, but they can tax them. And if they tax them, they can create a registration system to make sure the tax is being paid. That was the deal. The registration was just an ancillary or helper system to ensure the $200 was hitting the government's pockets. But here's the problem for the ATF. You cannot have a helper system for a tax that doesn't exist. The plaintiffs have looked at the ATF and said, the game is up. You told the Supreme Court in the 1930s that this was a tax. Well, the tax is now zero. Therefore, your authority to demand registration, your authority to demand transfer approvals, and your authority to keep us on a federal list has vanished. Think about it like this. If the IRS told you that you had to file a 50-page report every time you bought a loaf of bread, but the tax on that bread was $0, they wouldn't be collecting taxes anymore. They would just be tracking bread. And the federal government doesn't have the power to just track things for the sake of tracking them. That is why this case is so dangerous for the DOJ. They aren't just defending a law, they are defending the very foundation of their power. And because they know their constitutional argument is weak, they've started to resort to some very shady tactics. Both sides, both the plaintiffs and the DOJ and the ATF, are essentially trying to end this case as quick as possible. And they're trying to do that through cross motions for summary judgment. Essentially, without going to a full trial, they're trying to end this case mainly based on the briefs and the arguments that they're submitting to the court. So, how exactly is the Department of Justice, under a Trump administration and led by Attorney General Pam Bondi, trying to justify keeping the NFA alive when the tax is gone? You'd think an administration that claims to be pro-Second Amendment would take this opportunity to concede, but instead, they've doubled down. In the original brief, the DOJ made several key arguments to try to defend the remaining NFA restrictions. They have launched a three-pronged defense that is, quite frankly, an alarmingly expansive theory of federal power. First, they've come up with what they call the web of regulation argument. The DOJ says that even though the making and transfer tax is now $0, there is still a special occupational tax, or the SOT tax, on manufacturers, dealers, and importers. They argue that the registration system is part of this web of regulation that helps to enforce the remaining tax, and therefore still fits within Congress's taxing powers. The DOJ is telling the court, okay, sure, the $200 individual tax is zero, but look over here, we still have the special occupational tax. The DOJ is arguing that even though you don't pay a tax on your suppressor anymore, the government still needs your registration data to make sure the dealer you bought it from is paying their SOT. Essentially, they are trying to use a tax on a business to justify a registry of every individual citizen. It's a reach of epic proportions. They are claiming that your private information is necessary and proper to enforce a tax that you don't even pay. Their argument is, well, yeah, individuals don't pay a tax anymore, but businesses still do, and we need the registration system to make sure those businesses are paying their taxes. But they didn't stop there. The DOJ's second argument is a classic federal fallback, the Commerce Clause. They are arguing that the NFA is independently valid under the Commerce Clause because it regulates firearms that are moving across state lines and are moving through interstate commerce. They say even purely intrastate activity, like making a suppressor at your home or making them exclusively within a state, like some states like Texas have tried to do, can still be regulated because unregulated submarkets would create this whole gaping hole, they claim, in the federal scheme. They are citing the old Reich medical marijuana case to say that if it's an economic activity, the federal government can control it, tax or no tax. So even if you're making a suppressor in your garage in Texas and you never take it across state lines, the DOJ argues that Congress can still regulate it under the Commerce Clause because if they didn't regulate it, it would undermine their broader regulatory scheme. And finally, and this is the part that has really set the Second Amendment community on fire, the Trump DOJ is actually arguing that the NFA doesn't violate the Second Amendment because these items aren't arms in common use. They say that even if the court finds a constitutional problem with some of their arguments like the Commerce Clause and the taxing powers, this is still valid because it does not violate the Second Amendment. They are relying on United States versus Miller, a case from 1939, to claim that short-barreled shotguns and suppressors are dangerous and unusual. Think about that. In 2026, with millions of suppressors in circulation and short-barreled rifles becoming the standard for home defense, the government is still trying to tell a judge that these items are so unusual they don't deserve constitutional protection. It is a stunning betrayal of the rhetoric we've heard from this administration. They're basically saying, well, even if we lose on the taxing power argument and we lose on the Commerce Clause argument, it still doesn't matter because the Second Amendment doesn't protect these items anyway. Now, this brings us to the shenanigans I mentioned at the top of the video. As this case moved into the summary judgment phase, both sides submitted their final briefs. The plaintiffs laid out a devastating rebuttal showing exactly why the DOJ's SOT tax argument was a legal fantasy. After the plaintiffs responded to the DOJ's arguments, the DOJ then filed a reply brief and they attached a brand new declaration from the ATF. The DOJ saw the writing on the wall, they realized their case was weak, and that's when they decided to play dirty. In the Northern District of Texas, there are very strict procedural rules. One of the most important ones is that you are not allowed to introduce brand new evidence at the reply stage without getting express permission from the judge. The reply brief is supposed to be for legal arguments only. If you want to bring in new evidence, you have to ask the judge for permission. The DOJ didn't ask. Instead, they tried to sneak a brand new declaration from the ATF into their reply brief. They attached a sworn statement from a high-ranking ATF official that they had never mentioned before. That declaration tries to claim that the NFA's registration system is still necessary because the ATF supposedly denies hundreds of applications each year due to the SOT tax issues. Why? Because they were trying to fix the holes in their case after seeing the plaintiff's arguments. It's what lawyers call taking a second bite at the apple. You aren't allowed to wait until the very last second to drop a bomb of evidence just because you realized your original evidence was terrible. But the plaintiffs here are essentially pointing out that there's a huge problem procedurally with what they just did, and then also their arguments don't support what the Trump DOJ and what the ATF still want to do with the remaining NFA restrictions. You see, in litigation, there's a specific process. You file your opening brief with all your evidence. The other side files their response with their evidence, and then you get to file a reply brief, but that reply brief is supposed to respond to the arguments made by the other side. It's not supposed to be an opportunity to introduce brand new evidence that you could have submitted months ago. The plaintiffs argue that the DOJ already had months to submit evidence to the court to support their legal arguments, and the Trump DOJ already filed one affidavit. This new declaration is just a second attempt to kind of fix the weaknesses in their case after they saw the arguments that were presented by the plaintiffs. So now the plaintiffs have filed a motion asking for the court to strike that new evidence entirely, or at the very least give them the ability to respond to what the Trump DOJ just submitted to the court. They are asking Judge Reed O'Connor to completely throw out the ATF's last-minute declaration. They are arguing that the DOJ shouldn't be allowed to break the rules just because they're the government. What was in this sneaky declaration? This is where it gets even more insulting. The ATF claimed that the registration system is still vital because in 2025, they supposedly denied 691 applications specifically because of issues related to the special occupational tax. They thought this was their gotcha moment. They thought they could tell the judge, see, we need the registry. Look at these 691 people we caught. But the plaintiffs, including Gun Owners of America and the Silencer Shop Foundation, didn't just get mad. They got their calculators out. And what they found when they looked at those numbers completely blew the DOJ's sneaky play wide open. The plaintiffs don't just attack the procedural error and the sneakiness that happened with the Trump DOJ, but they also attack the substance of what is claimed by the DOJ with this new piece of evidence. The plaintiffs pointed out that in that same year, 2025, the ATF processed more than 2.1 million NFA transfers. Do the math. 691 denials out of 2.1 million applications. That is a denial rate of 0.03%. Think about that for a second. The DOJ is arguing that we need this entire registration system, we need all these restrictions, we need all this federal oversight because we have to enforce the SOT tax on businesses. But their own evidence shows that out of 2.1 million applications, they only denied 691 based on SOT issues. That's 0.03%. That's basically a rounding error. The plaintiffs are now telling the court that the DOJ's own sneak evidence actually proves the plaintiff's point. If the system only catches a tax issue in 0.03% of cases, then the registry isn't meaningfully connected to tax collection at all. It's just a massive, unconstitutional tracking system masquerading as a tax tool. It proves that the registration system has almost nothing to do with tax collection and everything to do with maintaining a registry and maintaining control over these firearms. It's like the government demanding a GPS tracker on every car in America just in case someone forgets to pay a $5 toll once every 10 years. Now, as if the 0.03% denial rate wasn't embarrassing enough for the Department of Justice, there is an even bigger flaw in this sneaky evidence they tried to drop. The plaintiffs have pointed out a massive, glaring timeline issue that makes the DOJ's entire declaration essentially worthless. They also argue that this declaration relies on some past practices under the old law, where there was still that $200 tax, but now we live under the $0 tax, and that has changed. Remember, we are living in the post-HR 1 world. The tax is $0. But when the ATF gathered this data about the 691 denials, they were largely looking at data points from the old system. The plaintiffs are arguing that the DOJ is trying to justify the current $0 tax reality by using stale evidence from the era when the $200 tax was still in place. It is a total apples to oranges comparison. You cannot use the behavior of a system that was built to collect $200 and say it proves the necessity of a system where $0 is collected. The legal landscape has fundamentally shifted. The DOJ hasn't presented a single argument, not one, explaining why these same procedures are relevant going forward under a $0 system. The tax has been eliminated, and it does not explain why those same procedures make sense going forward under the new $0 tax system. They are essentially haunted by the ghost of the old NFA, trying to apply 1934 logic to a 2026 reality. They're just hoping the court doesn't notice. This leads us to a broader, more frustrating point about how these lawsuits actually work. The plaintiffs in this case, the groups defending your rights, have to follow every single court rule to the letter. If they miss a deadline by 5 minutes, or if they format a brief incorrectly, the government's lawyers are the first ones to jump up and demand the case be dismissed. But here, we see the Trump DOJ and the ATF playing fast and loose. They realize their arguments about the web of regulation are failing. They realize the Commerce Clause argument is on shaky ground. So they decide the rules don't apply to them. They decide to sneak in evidence to bolster a weak position after the clock has already run out. The plaintiffs are pressing Judge O'Connor on this very point. They are asking the court, is the government above the law? If the DOJ can just ignore procedural rules in the Northern District of Texas to fix their mistakes, then the rule of law doesn't actually exist. It's just a rule for thee, but not for me. This procedural fight isn't just a boring legal technicality, it is a fight for the integrity of the judicial system. If the judge allows this evidence to stand without giving the plaintiffs a full and fair chance to dismantle it, it sets a dangerous precedent for every future Second Amendment challenge. As the plaintiffs put it in their motion, the DOJ had months to gather this data. They already filed one affidavit earlier in the case. They knew they needed to justify the SOT connection, but they waited until the very last brief, where the plaintiffs aren't even supposed to be allowed to respond, to drop this new data. It was a tactical ambush designed to prevent the plaintiffs from pointing out how ridiculous that 0.03% number actually is. So in short, they argue even the DOJ's new evidence doesn't fix their constitutional problems and the arguments that they're presenting in this case to support the remaining NFA restrictions. The DOJ's attempt to ambush the plaintiffs has backfired. Instead of saving their case, they've highlighted exactly how desperate they are. So where does this leave us right now? We are at a critical crossroads. The court now has two choices. Option 1. The judge agrees with the plaintiffs and strikes the evidence. If that happens, the DOJ is stuck with their original weak arguments. They will have to defend the NFA without that 691 denials data point. In that scenario, their chances of winning on summary judgment plummet. Option 2. The judge allows the evidence, but gives the plaintiffs a sur reply. This would be another round of briefing where the plaintiffs get to officially put that 0.03% number into the record and tear the ATF's declaration to shreds. Either way, it's going to be up to the court whether they strike that evidence, get rid of it, or at least let the plaintiffs respond to what the Trump DOJ tried to sneak in. And let's be clear about the stakes here. This isn't just about whether you have to wait for a tax stamp. This is about the future of the National Firearms Act itself. If the plaintiffs win this case, it could mean the end of NFA registration requirements, the end of transfer restrictions, the end of the entire regulatory framework that has governed suppressors, short-barreled rifles, short-barreled shotguns, and any other weapons for decades. If the court rules that a $0 tax means the registration power is gone, the NFA effectively collapses. The SBR registry? Gone. The Suppressor registry? Gone. The SBS registry? Gone. We are talking about the biggest restoration of Second Amendment rights in our lifetime. It would be one of the most significant Second Amendment victories in modern history. On the other hand, if the DOJ wins, it would establish a precedent that Congress can maintain regulatory systems even without the constitutional justification that originally supported them. It would mean that once the government establishes a regulatory framework, they can keep it in place indefinitely, even if the constitutional basis for that framework disappears. I also have to address the elephant in the room. A lot of people have commented that they're confused why the Trump DOJ and Pam Bondi are fighting this so hard. We were told this administration would be the most pro-gun in history, and yet here they are using the same sneaky tactics we saw from the previous administration to defend a law that everyone knows is unconstitutional. What's particularly interesting about this case is that it's the Trump DOJ defending these restrictions. A lot of people expected the Trump administration to be more favorable to Second Amendment rights, but here we have Pam Bondi and the Department of Justice actively fighting to preserve NFA restrictions, actively arguing that these items are not protected by the Second Amendment, and actively trying to sneak in evidence at the last minute to save their case. It shows you that the deep state in the ATF and the career lawyers at the DOJ don't just go away because the name at the top of the letterhead changes. They are institutionalists, they want to keep their power, they want to keep their registries, and they want to keep their control. This shows that regardless of who's in the White House, the bureaucracy and the institutional interests of federal agencies often remain the same. The ATF wants to maintain its power, the DOJ wants to maintain the regulatory framework, and they're willing to bend the rules, they're willing to play procedural games to make that happen. It is up to us and groups like GOA and FRAC to hold their feet to the fire. We have to call out these shenanigans when we see them. We cannot give them a pass just because of the party they belong to. But the plaintiffs in this case are not backing down. Gun Owners of America, FRAC, Silencer Shop, Palmetto State Armory, Silencer Co., and the multiple states that have joined this lawsuit are all pushing forward. They're calling out the procedural violations, they're dismantling the DOJ's substantive arguments, and they're forcing the court to confront the fundamental constitutional question: can Congress maintain a regulatory system when the constitutional justification for that system no longer exists? The plaintiffs are standing their ground, refusing to let the government play by a different set of rules. This case is a massive test of the limits of federal power. It tests the limits of Congress's taxing power, it tests the Commerce Clause, and it tests whether the Second Amendment truly means what it says. The DOJ tried to play a game of legal hide and seek, and they got caught. And I'm going to be right here watching every single filing that comes out of this court. If Judge O'Connor strikes that evidence, it's going to be a massive signal that the court is ready to take a hard look at the NFA's constitutionality. If he doesn't, we prepare for the next round of the fight. But one thing is certain: the momentum is on our side. The math, that 0.03%, is on our side, and the Constitution is definitely on our side. This is one of the most important Second Amendment cases in the country right now, and it's one that a lot of people aren't paying attention to because it's happening in the details, it's happening in the procedural motions, it's happening in the briefing, but this case could reshape the entire landscape of federal firearms regulation. The ruling on this motion to strike could come any day now. If you like this video and you would like to support the work that goes into breaking down these critical cases, one of the best ways to do that is simply to like, comment, and subscribe. Every like and comment helps us beat the algorithm that tries to suppress Second Amendment content. It tells the algorithm that you appreciate this type of content and it should share it to more people. As we get more information, as it develops more, I will let you know.